Hello, Daniel Barnett here from Outer Temple Chambers, and welcome to episode 61 of Employment Law Matters, part 2 of GDPR 2 years on. Now, if you listened to last week's episode, you'll have heard me explain that this raw episode, the recorded interview with Emma Erskine-Fox, a data protection specialist from TLT Solicitors, has been sitting on my Chambers computer for the last few months because we recorded it back in March, just before lockdown was announced. And I didn't, perhaps very inefficiently, send it straight off to my audio editor the moment that lockdown was announced, which meant that we recorded it, we went for lunch, I went home in the evening, and then I didn't come back into Chambers again. And it's only in the last few days that I've been back into Chambers to be able to collect some files I needed. We're now in August 2020 as I record this. Collect files I needed and indeed pick up the unedited raw interview files with Emma Erskine-Fox. So now they've been edited, it's a bit weird because what we're doing in this, which was recorded in March, is pretending it's May, 2 years on from GDPR coming in, even though it was March when we recorded this, but you're now hearing it in August, and you'll hear us discussing things which will seem really antiquated and dated and quaint to you. We discuss things like what will happen if people have to work from home more, because back when we recorded this, Boris Johnson hadn't announced lockdown. So with that caveat in mind, I hope you enjoy this episode. It's the second half of my interview with Emma Erskine-Fox from TLT Solicitors on GDPR 2 years on. Hello, Daniel Barnett here, and thank you so much for listening to today's episode of Employment Law Matters. I'm joined in this episode for part 2 of my recent interview with Emma Erskine-Fox, who's an associate in the data protection and privacy team at TLT Solicitors. In last week's episode, Emma and I discussed general issues relating to the GDPR and the Data Protection Act 2018. We went into detail on what a request has to constitute and how you deal with phishing requests, multiple subject access requests, and circumstances when companies can refuse to respond. Incidentally, that's not very common. And we also discussed the deadline for responding, when it's 1 month, when it's 3 months, when the clock starts, and when the clock stops. In part 2 of the interview, I discussed with Emma the extent of the search. What do employers need to search for? What happens when there's information that you want to redact, and how do you go about redacting it? How do you search for initials? Can you ask employees to narrow the search? And I'm also going to be asking Emma 10 or so questions that have been tweeted into me. And these are questions that she doesn't know are coming, and we're going to see if we can take her by surprise so that she can demonstrate the level and range of her knowledge being able to answer these sorts of questions off the cuff. So this is now part 2 of my interview with Emma Erskine-Fox.
Welcome to Employment Law Matters with Barrister Daniel Barnett.
Emma, what I'd like to discuss with you now is the extent of the search that employers have to carry out. What do they need to search for?
So what you're searching for, and this sounds possibly quite basic, but it's always helpful to bear in mind, I think, what you're searching for is personal data about the individual. And that may not be necessarily every single mention of that individual's name. Common issues we see around this, for example, minutes of meetings where somebody might have been listed as an attendee at that meeting in the minutes, but actually that's the only data about that person on that particular document. That wouldn't be enough to constitute personal data for the purposes of a data subject access request. So that sort of data wouldn't need to be provided. So really what you're looking for is information that tells you something about the person, that has some sort of biographical significance or is an opinion about a person, and that always raises some interesting issues as well. Something from which you can, infer something possibly about the individual, but certainly more than just a name on a document. That's never going to be enough to make it personal data.
Something we often see requested is, will you send me a copy of every email I've ever sent and every email I've ever received or been copied into? Would that fall within a subject access request?
Again, some of those might do. Absolutely, but it's not enough just because an email came from somebody, just because they happen to send that email, that doesn't make that entire email personal data. If you're sending an email that's, chatting about the weather or, talking about something to do with the business, that doesn't have any sort of personal significance, or even if you're just, if somebody sent an email that's kind of having a moan about a colleague, then the person sending that email, that wouldn't constitute their personal data just by virtue of the fact that they were the sender of that email.
What needs searching? Do you need to search, does the employer need to search every single manager's emails? Do they need to search every manager's texts or the WhatsApp communications and chats?
Yeah, texts and WhatsApps are throwing up a lot of interesting issues at the moment. Broadly, what you have to do is look at which systems are most likely to hold personal data. So when that comes to emails specifically, which you've asked about, you wouldn't necessarily need to search every manager's inbox and sent items, etc. What you would be looking to do is put together a list of the other individuals within the business who are likely to have personal data about that person in their mailbox. So that would probably be line manager, possibly any direct reports or any other people that they happen to work closely with in their team. If there have been any sort of HR issues, disciplinaries, grievances and things, then the people within the HR team who were dealing with that. But it's certainly not a case of having to search all inboxes across the business or even all managers' inboxes.
Imagine, Emma, that I'm your line manager and you put in a subject access request asking for all the information I have about you. I've sent a number of texts on my personal phone, so not my work phone, my personal phone, which I routinely use for work because work doesn't issue me with the phone, but it's still my personal phone. Would that fall within the scope of the request?
So if there are, this is quite a complicated issue and we're dealing with this in real life at the moment, as it were, for a particular client. Texts that are on, certainly texts on a work phone, and we'll take that first because that's the easy one. Texts that are on a work phone, arguably, good argument to say that they do fall within the scope of what has to be searched and disclosed. Texts that are on a personal phone, and again, for simplicity for the moment, we'll take a personal phone that's not used for work purposes, wouldn't fall within the scope of that. When it comes to personal phones that are used for work purposes, that is when it does start to get a bit thornier, because there's an argument that if, as an employer, you are allowing your employees to use their personal phones under what we call a bring your own device or BYOD policy, then data that's on those phones that's processed in the context of work, in the context of that person's employment, would possibly fall within the scope of that request. Now, it depends really on what your policies are. We often see employers having bring your own device policies. If that makes it very, very clear that all the data that's held on that device is to be treated as the employer's data under the control of the employer, and that, as an employee, if you're using your own device, you have to submit that device for searching, etc., it's then going to be very difficult to argue that that data isn't subject to the scope of the request.
So I'm a big company. I've got a ton of data on an individual and they send me a subject access request, and it would involve going to all sorts of places to look it up. Can I ask the employee to narrow down the parameters of their search?
So it's interesting that you use the word narrow, because we generally try to avoid using that term. And that's because whilst the Information Commissioner's Office makes it very clear that there is scope to clarify certain details with the individual, and there is scope to help them to focus their search, they don't really like any implication that you're trying to get the data subject, trying to force the data subject to submit a narrower search. The ICO does encourage kind of constructive communication with requesters to say, well, look, okay, you've asked for all this data, but actually what is it you're interested in? We want to help. We want to make sure that our response is something appropriate for you and something useful for you. What is it you actually want? The ICO absolutely encourages that, and that's a great thing to be able to do. But they are equally clear that the employee doesn't have to do that, doesn't have to refine their search or make it any more focused. And if they don't, then they are entitled to ask for everything. So then you get into thinking about, what are the sort of search parameters that you need to put around that to make that reasonable and proportionate?
One issue that a lot of employers struggle with is the problem of common names, or
Yes.
even searching for initials. Now, until a few years ago, if you searched for me on YouTube, the first video returned on YouTube was called Daniel Barnett at a Party, and it was a picture of a 18 or 20-year-old American student vomiting into a toilet, which wasn't really great for me when someone typed my name into the internet.
That's ideal.
But obviously, if someone's got a common name, there's going to be a huge number of returns when you do an electronic search. How do you deal with that?
Yeah, again, we see this a lot, and I'm the same. My my unmarried name was Emma Fox. Again, a very, very common name. So yeah, absolutely sympathise with that, although I'm not sure I saw any YouTube results of students vomiting into toilets for me. If you're faced with that conundrum, then there are a number of things that you can do to deal with it. You can refine other areas of your search. So, for example, I might have been, one of several Emma Foxes. For example, I'm not at my firm as far as I'm aware, but if I was, I might have been. But I would probably be the only Emma Fox who's managed by my line manager. And therefore, you could say, well, okay, when we're searching my line manager's inbox, we will search for Emma Fox because he's not likely to have any information about any other Emma Fox, or if it is, it's going to be very minimal. So you can help yourself by refining other search parameters around that. You can do things like search for other identifiers instead, such as employee numbers and payroll numbers and things like that. But really, it's about looking at your search as a whole and looking at which other parameters you can put around that to make sure that you are getting the right information and getting the information about that person, but without, as you say, ending up with a bunch of information that's completely irrelevant to that person.
Yeah. So imagine with your name, an employee, rather you put in a subject access request saying, can you send me all information containing the search term Emma or containing the search term EF? Yeah. What should an employer say in response to that?
So we do very often see employees trying to set out what search terms they think employers should use. They're perfectly entitled to do that. And, it's probably best practice to at least take those into account. But you don't have to be kind of tied to those. Just because I've said search for everything with the name Emma, that doesn't mean, or search for EF, that doesn't mean that you have to do that by any means. So you would be looking at whether those search terms were reasonable and proportionate. And, Emma, again, very, very common name, arguably not reasonable just to search for Emma. I think there are probably going to be fairly limited circumstances in which it would be reasonable to search just for somebody's first name, unless they had a particularly unique first name. And similarly with initials, this is a massive problem. I can't immediately think off the top of my head of any word that includes the letters EF consecutively, but there are plenty of other people's initials that, will appear in hundreds of different words. And we've seen that before where, we've been doing these reviews for clients and we've seen a document that has, no relevance at all to the data subject or even a name or anything like that. And then we've realized that it's in the document set because of the initials, and the initials just happen to appear in another word. So again, I think it's going to be quite rare that it will be reasonable and proportionate to search for somebody's initials. You don't necessarily need to go back to the data subject and tell them that you're not going to use those as search terms, because it's for you as the controller to be accountable for compliance and accountable for determining what your reasonable and proportionate search looks like.
Let's have a little chat about redaction. We all know, of course, that you can redact information that relates to others. How does that work?
So I mentioned it briefly in our last episode, I think, in the first half of the interview, that you don't need to disclose personal data to the extent that doing so would breach the GDPR in respect of somebody else's personal data. There's a slight caveat to that, where if it's reasonable in the circumstances to disclose a third party's personal data, then you can do that. But most of the time, you would kind of fall down in favour of disclosure to protect those third parties' rights. So there are some really obvious examples of this. So, we very often see if there are internal emails, by internal, I mean emails that don't include the data subject, so that they haven't already seen those emails, but emails between two other colleagues, you would very often redact the to and the from and the greetings and the sign off and all of this to protect their rights. Similarly, if there's a sentence that's very clearly about somebody else within that email, then you would redact that. Where it gets a little bit trickier is where there are opinions about people, or things like if somebody has raised a complaint about another employee and that information, that opinion or that complaint is simultaneously the personal data of the person against whom that complaint is made, or about whom that opinion is, and the personal data of the person who has expressed that opinion or made that complaint. And that's where it gets a little bit tricky, and that's where you have to think about it kind of on a case by case basis, and whose rights win essentially. And if it's a situation where, again, we've seen this with some of our clients, if there's a situation where there is quite a sensitive complaint that's been made, and it's, possibly the subject matter of that is, this isn't actually, necessarily a real example, but, if it's a sexual harassment type complaint, then there might be, you'd probably fall down in favour of withholding that because of the nature of that data and the sensitivity of that data. If it's a case where somebody has just decided to have a moan in an email, have a rant about a colleague, and they said, I'm really fed up of my manager, and then manager makes a subject access request, then that would probably fall down in favour of disclosing the information. Although, again, you would redact the information about the person who had made that statement. There might, the requester might be able to deduce who that is, but you would redact the names.
Another common ground for redacting, although it's not quite as common, is legal privilege, where there's an element of confidentiality because it's discussions with a lawyer. Now, a lot of people think that by copying lawyers into an email, it suddenly becomes immune from disclosure. Is that right?
Not quite. It could be. It will depend on the particular email and the particular document. So there are two different types of privilege. You've got legal advice privilege, which applies to communications for the purposes of giving or receiving legal advice with your lawyers, and that's in-house lawyers as well. But it does have to be information that is for the purposes of giving or receiving legal advice. So, as you say, if you are just copying a lawyer into an email, but that email is more for information for them, and it's not necessarily for the purposes of actually taking advice from them, then that's unlikely to fall within legal privilege. The second type of privilege is litigation privilege, which applies to any documents, not just correspondence, that are prepared in contemplation of litigation and for the sole or dominant purpose of litigation. So that could apply to, internal meeting notes and things like that, as well as correspondence. But again, it has to be with litigation in mind and for the purpose of litigation. So in practice, it's a little bit narrower than you might think it is. Where we see this arising actually in the employment context particularly is in relation to employee investigations, and often documents that relate to an investigation into an employee won't necessarily fall within privilege. And I think they sort of feel like the types of documents that should because of the nature of them. So it can catch people out. So you just need to be a little bit wary and make sure that you are applying that privilege test to each document. Yeah,
I've actually had in the last couple of years more than one inquiry from somebody who I've cross-examined in a tribunal or been against on paper in court, where they've asked me for a copy of my file because they know I'm the employer's lawyer.
Yeah.
And I've just got a standard response that I send back, which says, "Dear Mr. or Miss X, I'm afraid if I possess any personal data about you," I mean, they know I do because I've cross-examined them. "If I possess any personal data about you, legal professional privilege applies and the duty of confidentiality is owned. It's exempt from disclosure." Then I give them a link to it's paragraph 19 of Schedule 2 to the Data Protection Act. And then I go on to say completely pointlessly, "This should not be taken as an admission that I do possess any personal data about you. I'm sorry I can't be more helpful." And no one's ever come back on that. I've never been referred to the Information Commissioner's Office for breach of the Data Protection Act or GDPR. But it is slightly bizarre that people think they can get hold of the opposing lawyer's files just by asking for it.
Yeah, there's a lot of misconception generally about what a data subject access request gives you, what rights it gives you. And that's, I think, one of the key challenges that our clients see is that people expect to get a lot more than they actually do get. And actually what they're entitled to is, much more limited often than the information that they are trying to get hold of.
Now, I have one of the fearsome black pens, which when I'm doing redacting, which isn't very often I use, but I know I live in the Middle Ages. How common is it to still use a black pen for redacting, and what other alternatives are there? So
I think it's still fairly common. What you need to be really careful of is that often if you redact with a black pen, you'll be very aware of it, you can see through the black pen. So you need to photocopy it.
Copy it, scribble again.
Yeah, exactly. Do it again, photocopy it again to make sure that you can't see through that black ink effectively. So we do still see it. It is getting increasingly common for businesses to use technology to help them with this. So we provide a fully outsourced DSAR solution to a number of our clients at TLT. And we use the help of several different third-party technology platforms to do this. And the reason they're brilliant is there are many, many reasons that they're brilliant. They can really help you with your searching and with your refining and narrowing of your data set. So they can do things like automatically remove duplicate documents and earlier email threads and things like that. But then they also have really effective redaction tools. So you can go in, you can outline the bits that you want to redact, or, if you want to redact most of a document, you can outline the bits that you don't want to redact and it will redact everything else for you. And they're really good. We have a number of different providers. The most common ones we use are called Relativity and Servient. And I would really recommend anybody listening who's having problems with DSARs to start looking into those tech solutions. Those are by no means the only ones. There are several out there. There are some emerging as well that sort of use AI technologies to help with the sifting and with the searching and things. So definitely I'd recommend doing some research into those types of tools.
Now, under the Data Protection Act, you don't actually have to provide copies of the documents in which personal data is contained. You merely have to provide a copy of the information that you store or process, to use the correct word. So I've said a couple of times, tongue-in-cheek, that it's okay if you want to give somebody all the information that they're asking for, but in 8-point courier, fully justified with no line breaks, and that way you're complying with the statute. Am I right, or am I being a little bit too tongue-in-cheek?
That's certainly tongue-in-cheek. I think it's absolutely right that you don't need to provide copies of the documents. Generally, people choose to do that with the redactions because it's easier than kind of extracting the information out. We do see some clients, if there are documents that are particularly heavily redacted, they will, instead of providing the redacted document, they will pull out the data that they are going to disclose and put that into a separate document. So they will have a kind of extraction table or an extraction document. One of the things that is important to bear in mind is that you do need to make sure that the data is provided in a way that is comprehensible to the data subject, so in a way that they're going to be able to understand. And I think there's possibly an argument that, if you do it, as you say, 8-point courier, fully justified, that loses some of the meaning for the data subject. I'm not sure how delighted the ICO would be about that approach. I'm not saying it's, out of line completely with the legislation, but I think treated with a bit of caution.
So you're saying 9-point rather than 8-point?
Yes, absolutely.
All right. So, Emma, thank you. We do have some questions that have been sent in.
Yes.
And before I turn to them, I actually have one of my own,
Yeah.
which is simply this. We often see in settlement agreements a clause that says the employee promises to withdraw their existing subject access request and not make any further subject access requests.
Yeah.
Are those sorts of clauses legally enforceable?
I think the answer in terms of whether they're enforceable is probably no, because it is a statutory right. But there's nothing to stop you having the clause in there, and it can act as quite a helpful deterrent. It just means that if somebody did then make a further request later down the line, you'd struggle to say that they couldn't make that because of the settlement agreement.
Let's turn to some questions that have been sent in. These have been sent in via Twitter and Facebook. The first one comes from Carl, and Carl asks, how different could a UK alternative to GDPR be without ruining the ability of UK firms to do business outside the UK? So what Carl's really asking is, if we, once we've finally gone from Europe, decide to abolish or change GDPR, is that going to cause problems for businesses?
So it's a very good question. The European Commission absolutely will still expect the UK to have high levels of data protection. And even though there have been some noises made by the government about possibly deviating from the GDPR, I don't think anyone's suggesting that we are going to significantly lower our levels of data protection. So it will depend on how the negotiations go in terms of, whether we get what's called an adequacy decision from the European Commission to say that they can send data to us.
We've had a couple of questions on staff working from home in the light of coronavirus concerns. So a question from Julie is, what sort of things does an employer need to take into account, data protection-wise, when sending staff home to work?
Yeah, another really good question. And I think the key is having really robust sort of home working, remote working policies in place and making sure that your technology is sufficient to enable your employees to do that. So people aren't having to, pull data off company systems and keep it locally in order to work from home. Certainly try and avoid, where possible, using kind of personal email addresses for work type activities if you can. I think there's a little bit of a common sense approach to be taken with coronavirus because obviously businesses need to continue being businesses. But yeah, just make sure that your technology is adequate and your policies are robust.
And there's a question from Kate as well, which is similar, but it's quite interesting. One of our directors wants to ask its worldwide staff for their home phone numbers in case they have to work from home. The director then wants to share this list of staff home phone numbers with a manager based in Houston, Texas, and a manager based in Canada, where, of course, the GDPR doesn't apply.
Yes.
Can they do this? And if not, what's the best way to tell my director they can't do it?
So the full answer to this probably takes more time than we've got to answer this. I would say that this is a low-risk data processing activity. It's something that clearly when you ask employees for these numbers, you've got a chance then to explain to them why you need it and for them to raise any objections if they have any issues. I think it's best to explain to them at that point where that data is going to go, the fact that it will go to Houston and Canada, but I wouldn't necessarily be too panicky about it because it is, as I say, it's very low risk data, and I would say in this context within those employees' expectations.
Interesting question from James. James asks, is there any implication to keeping voice recordings of people in relation to GDPR. Now, James could be talking about, for example, recorded disciplinary or grievance interviews, but I happen to know because he runs a podcast studio near where I live, and it's a really good one. If you're interested, have a look. www.launchpodstudios.com. He's actually thinking about keeping interviews such as this one, Emma, on podcast till time immemorial.
Yeah. Great question. I mean, again, very low risk. There's probably a question around whether somebody's voice alone is sufficient to identify them, and therefore is personal data. When you and I haven't been talking about anything, apart from you mentioning that I'm a runner and a singer in the previous episode. I've certainly not said anything that I'm particularly concerned about somebody keeping. So, I think what's important is to make sure that people are aware that that is what you're doing, and that they're given the chance to kind of raise any objections. But again, in this kind of context, in a podcast, I wouldn't be too concerned about it.
Liz asks, is it compliant with the GDPR to share delegate lists from conferences and events where those lists include names and email addresses, where the email address is in the public domain? So, I assume she means findable with a Google search.
Sure.
Can those sorts of delegate lists be shared anymore?
Answer is almost definitely yes. Again, it's more a transparency issue than anything. Just make sure that you're telling people up front that that's what they're going to do. So when somebody signs up for the event, that it's clear that that information will be shared with other people in the event, and that they are given a chance to raise any objections to that, although quite why anybody would object, I'm not sure.
Susie has asked a question that we touched on in the last episode. She asked for your thoughts on the hypothetical use of subject access requests to deliberately disrupt workplace management. And she says, is it something we might start to see occasionally in the future? You were saying in the last episode, you're seeing it quite a lot at the moment.
Yeah, we do. We are starting to see this. Less so in employee DSARs at the moment, but certainly for some of the banks in relation to their customer DSARs, and claims management companies are submitting, massive DSARs for huge groups of people. I think it will come down to whether that can be said to be manifestly unfounded or excessive in the context, which, as Daniel said, we had talked about a little bit on the last episode. But if it is something that is very clearly just to disrupt business with no sort of basis for those individuals to want to get hold of their personal data, there might be a manifestly unfounded argument, but it's a little bit difficult at the moment because of the lack of guidance.
Helen asks for some practical advice on how to handle requests to external independent HR professionals, because external HR professionals don't have legal privilege. How should those HR consultants handle requests to send their files to an employee whose case they might be advising on? It's a really tricky one, this.
That's really tricky, and one of these where there's probably not a whole lot you can do about it, because as Helen has quite rightly said, they wouldn't attract legal privilege. And again, we touched on it earlier, those sorts of consultants. So there's very little you can do in terms of marking things as privileged, because even if they say they're privileged, you still have to apply the test. I think that one of the things that can be really helpful is trying to build a culture, both within your organisation and with consultants, of keeping things as professional as possible in writing. And again, that sounds something that's really basic, but we do see a lot of challenges with that. And that can make a lot of the data much less sensitive, and therefore you're much less worried, I suppose, about disclosing it. Other than that, again, I think anything else to say on it is probably going to take us more time than we've got, unfortunately. But it is a very interesting question and definitely a challenge.
John asks a very similar question. John's also an independent HR professional, and he says, although this would apply to in-house HR as well, where do we stand when we write prep notes about an employee case, including what we think about the employee? If they see those notes under a subject access request, it might fuel a constructive dismissal claim, or maybe even a personal injury claim, some form of stress-related claim. Again, I suspect you're going to say something similar to John.
Well, I think this is one where, again, depending on the particular circumstance, there might be a privilege argument, but that's very, very dependent on the context. And another possible exemption that springs to mind is the negotiations exemption or management forecasting and planning. So basically, the negotiations exemption is about protecting records of your intentions in negotiations if disclosing it would prejudice those negotiations. So there might be that. And management forecasting and planning is if that information is processed for those purposes, for example, thinking about redundancies, thinking about dismissals, and disclosing that data would prejudice those purposes. So that might be the one to look at. in that sort of context, but difficult to say because it will be so case by case.
Yeah, it sounds like the sort of thing where I'd be saying to a client, these are the arguments you can run if you want to run something, but I wouldn't have much confidence.
Yes, yeah, I think so.
And last question comes from Lorna. Lorna asks, do work email addresses need to be redacted from all email communications when preparing a response to a subject access request?
Well, I think probably not all. We mentioned it briefly earlier, if you're disclosing third-party data and it's reasonable in the circumstances to do so, then that's not going to fall foul of the GDPR. So if it's information that the data subject in question already knows about those individuals, then you might argue that it's reasonable in the circumstances to disclose it. Where it might get tricky with emails is if those people who are sending and receiving the emails aren't saying things that are necessarily too favourable about the data subject, and that's where you might want to exercise some more caution.
Emma, thank you very much.
You're very welcome. Thank you for having me.
And that was Emma Erskine Fox, an associate in the data protection and privacy team at TLT Solicitors. You can find out more about her on the TLT website at www.tltsolicitors.com. And you can follow her on Twitter at Emma Fox Law. Please do consider leaving a review for Employment Law Matters on whichever podcast store you like to leave reviews on. And every week we read out a review on the podcast and we send a book to the reviewer as a little thank you for leaving that review. If you don't subscribe, what's wrong with you? Subscribe now. Go to www.danielbarnett.co.uk/podcast for information on how to subscribe to these podcasts, which come out every Tuesday morning. Thank you very much for listening. I'm Daniel Barnett from Outer Temple Chambers. Bye-bye.
Any information on this podcast is for general guidance only. Always seek legal advice. Please see full terms at www.danielbarnett.co.uk/podcast terms.